Hello to everybody, or good morning if you wish. I have the privilege, dear colleagues, to welcome among us Professor Michael Krennerich from Friedrich August University of Nuremberg, Erlangen-Nuremberg. I'm really glad that he accepted invitation made by Professor Muránsky, and he is going to give a lecture related with problem of social rights and with respect to human rights protection. Professor Krennerich has a doctorate in political science, philosophy, and public law from Heidelberg, as far as I know. He is a senior research fellow at Chair of Human Rights and Human Rights Politics, and also he is editor-in-chief, also leading person of the academic journal Human Zeitschrift für Menschenrechte, also Journal for Human Rights. He has been also involved, engaged in activity related with electoral reforms and human rights politics in Europe, in South Europe, in Balkan, and also in Asia, and also in Africa. Also, he has a great expertise. And now I had to add that among his publication about human rights issue is worth of mentioning, to my mind, his book, Human Rights between Social Human Rights, Social Human Rights between Law and Politics. Also, proceedings which that has been published recently. I have 2030, okay, with under title Freedom of Human Rights. Also, I had to add that chair of this talk will be held by Professor Muránsky, and now the floor is yours, Professor Krennerich.
Thank you very much, Tanya. Maybe just one very personal remark. This is 6 years ago when in this room we were together with Professor Georg Lohmann and Arne Pollmann, and they hold their lectures dealing with the book about human rights in interdisciplinary approach. And I would like to use this opportunity and to recall this event to our common memory, because I'm very proud that we could preserve the continuity in the research agenda, and I would like to introduce Professor Krennerich as a close friend of both personalities, and if I say that this week will be held in the memory of Georg Lohmann, it would be not exaggerated. So the floor is yours, Michael. Looking forward for your lecture. Just one micro.
Yeah, ladies and gentlemen, I'm extremely pleased to be here. I must admit that that I am visiting Slovakia for the first time here. And so I'm already impressed how friendly the people are here. Thus, thank you very much for the invitation. It would be nice if today's invitation could develop into an academic exchange, perhaps, as already been encouraged by Professor Muránsky. I can assure you that the Center of Human Rights at the University of Erlangen-Nuremberg is very interested in such an exchange. Soon we will be setting up a fellowship program at our center, and this might be a good opportunity for further collaboration. And furthermore, as editor-in-chief of the Zeitschrift für Menschenrechte, Journal for Human Rights, I would also like to invite you, both young and established scholars from Slovakia, to publish in the journal. It is a bilingual journal in German and English. Well, you soon will find out that my English is not the very best, so if I don't explain myself, please just raise the hand and interrupt me. I was invited to talk about social human rights. Now, I don't know which rights you first think of when human rights are mentioned. In Germany, most people first think of the classic civil and political rights, such as the right to life, the prohibition of torture, protection against arbitrary arrest, fair trials, freedom of religion and belief, freedom of assembly and associations, as well as freedom of opinion and expression. My lecture, however, is about economic, social, and cultural rights, which are often far less well known, although they were altogether enshrined together with civil and political rights in the Universal Declaration of Human Rights of 1948, and later in numerous international human rights treaties. Social human rights include, among others, the rights to work and to just and favorable working conditions, the rights to social security, health, food, adequate housing, water and sanitation, and the right to education. For the sake of simplicity, I often just call these rights social human rights. Together with civil and political rights, economic, social, cultural rights form a context of interrelated rights. They are indivisible and interdependent. The times when social human rights were dismissed as mere political declarations and not real human rights are definitely over. Social human rights have gained considerably importance in the international human rights discourse of the past 30 years, or let's say 25 years. Today, social rights are an integral part of human rights discourse and human rights policy. I would like to talk about this gain of importance today. Well, now I'm a little worried at a lecture here today at the Institute of Philosophy, because I'm not a philosopher. Therefore, I will not give a lecture on the philosophical foundations of human rights. I hope you're not disappointed in that point. I personally assume that human rights can be justified in many ways, and I do not see the openness to different justifications as a disadvantage for the universal recognition of these rights. And more, there's something compelling about the idea of human rights that appeals not only to the mind of people, but also to their hearts. In any case, it seems to me that the persuasive power of human rights is based less on sophisticated justifications than on the evidence of concrete experiences of injustice. Many people who suffer injustice feel that their human rights are being violated and do not want to accept this. And this has something to do with the fact that a violation of human rights is an offense against the dignity of the human being. As a political scientist, I would also like to emphasize that human rights have political dimensions as well as more than legal ones. Human rights are already political because the state is the primary addressee of human rights claims and obligations. International law primarily obliges states to respect, protect, and fulfill the human rights of all people under their jurisdiction. Or to put it more generally, human rights refer to the relationship between those who exercise political power and those who are subject to it. Furthermore, human rights are also political because they have come into being in response to publicly articulated experiences of injustice. They are the result of political struggles waged against oppression, humiliation, and arbitrary state power. At the same time, human rights are subject to change and must always be politically reasserted and defended. The standard setting, the interpretation, and the implementation of human rights are to a large extent political processes. In the following, I would like to show how and why social human rights have gained considerably importance in the international human rights discourse over the past 3 decades. In doing so, I will also address the question how social human rights can be made concrete. Building on this, I argue for understanding social human rights as rights to freedom, equality, and solidarity. I hope we will also have time to work out how social human rights can be claimed or demanded. So, notwithstanding earlier historical human rights documents, such as the French Declaration of the Rights of Man and Citizen and so on, modern international human rights protection, at least in a comprehensive manner, only begins with the United Nations Charter of 1945, which commits itself, among other things, to the goal of promoting and consolidating respect for human rights. The Universal Declaration of Human Rights served this goal. Social rights are enshrined there together with civil and political rights. As is well known, it took almost 20 years before the rights of the Universal Declaration of Human Rights, with few exceptions, were transposed into 2 international treaties, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, Cultural Rights, both of which were adopted in 1966 and entered into force in 1976. The decision for 2 separate covenants had already been taken by the United Nations General Assembly in the early 1950s. Ultimately, all those positions had prevailed at that time that asserted fundamental differences between civil and political rights on the one hand and economic, social, and cultural rights on the other. For decades, the systematically unconvincing division between 2 alleged types of rights was politically solidified. Even if the dividing line was not always clear-cut between East and West, civil and political rights and economic, social, cultural rights were played off against each other with ideological sharpness in the context of the East-West conflict. And the North-South conflict also influenced the debate later on. In the decolonized countries of the Global South, social human rights were still diffusely woven into the demands for a new world economic order. For legal, dogmatic, as well as for political reasons, social human rights thus remained completely underexposed, at least in the dominant liberal human rights discourse of the West for a long time. They were seen as social benefits rather than real human rights. Thus, the International Covenant on Economic, Social, Cultural Rights languished in insignificance for many years. This only changed in the 1990s, and especially since the Second World Conference on Human Rights in Vienna in 1993, which emphasized not only the universality, but also the indivisibility of human rights. The prerequisite for this was the end of the East-West conflict, which may not have depoliticized, but certainly de-ideologicized the human rights debate. This opened up political spaces to take up the discussion on social human rights in international human rights forums and to link it back to social problems worldwide. In the following years, a growing number of advocates in civil society organizations, at universities, and in global and regional human rights institutions contributed to social human rights being placed on the political agenda, also by making efforts to give these rights a clear substantive profile, and thus a stronger binding force under international law. Let's look briefly at these actors of change that particularly interest me as a political scientist. The rise in importance of social rights, social human rights, would never have been possible without civil society organizations that demanded the implementation of these rights. In the 1980s, only a few human rights NGOs had initially begun to record, document, and criticize social grievances from a human rights perspective. They worked on the right to housing or on the right to food, and had a significant influence on the work of the United Nations Committee on Economic, Social, and Cultural Rights, which was founded in 1988. Over the years, many human rights organizations around the world would have joined the ranks, actively advocating social human rights and effectively lobbying global and regional human rights institutions and national governments. Even important transnational human rights organizations, such as Amnesty International or Human Rights Watch, which worked mainly on civil and political rights, started to work on individual social human rights in the 2000s. For example, Amnesty International launched a campaign on human rights dignity in 2003 or 4. The United Nations Committee on Economic, Social and Cultural Rights, which monitors the implementation of the International Covenant on Economic, Social and Cultural Rights, made a significant contribution to make the content of the rights concrete. Above all, the committee's so-called general commands, which contain a comprehensive interpretation of substantive provisions of the covenant, gained great authority. These general commands have been widely used both within and outside the United Nations to interpret social human rights and the resulting state obligations. This is just a selection referring to individual social rights. At the same time, UN special rapporteurs have sought to give social human rights a clear substantive profile. In cooperation with civil society organizations, they use their independent mandate to promote the understanding of individual social human rights, such as the right to food, to education, to adequate housing, to health, or later also to clean drinking water and sanitation. At the same time, negotiations and campaigns, at the same time, negotiations and campaigns to introduce an individual complaints procedure at the International Covenant on Economic, Social, and Cultural Rights revived the debate whether social human rights are in principle enforceable in court. This was enforced by case law of regional human rights monitoring bodies, especially in Latin America and Africa, as well by the progressive jurisprudence of national courts on the protection of social rights in individual states, such as South Africa, Brazil, or India, in the latter case, for instance, on the basis of the right to life. Furthermore, the number of academic publications on social human rights has increased enormously since the mid-90s. Together with experts from the United Nations and NGOs, these epistemic communities, the academia, changed the state of the art on the debate on social human rights. In short, social human rights have become an integral part of human rights discourse. The rise in importance of social human rights, however, was less due to establishment of new rights than to the rediscovery and reinterpretation of existing rights. This clearly shows that human rights treaties are living instruments. The interpretation of these rights enshrined in them must always be adapted to new conditions and is always legally and sociopolitically controversial. Why not? So, what was new in the interpretation of social human rights? The first thing that changed was the general understanding of social human rights. Whereas they were previously considered vague and indeterminate, they have now been made much more concrete. The categories of availability, accessibility, acceptability, and adequacy, used by the former UN Special Rapporteur on the right to education, Katarina Tomaszewski, have proved helpful in interpreting the content of many social human rights. The United Nations Committee on Economic, Social, Cultural Rights has applied these or similar categories to several other social human rights. So let me give you 3 examples how these categories can be used to get a basic idea of the content of these rights. First example, the right to education. The right to education firstly includes the availability of functional educational institutions and programs. Secondly, educational institutions and programs have to be accessible to all, especially to the most vulnerable groups, without discrimination. They must be within safe physical reach, and education has to be affordable to all. Thirdly, the form and substance of education, including curricula and teaching methods, have to be acceptable for students and parents, as well as from a human rights perspective. And finally, education has to respond to the needs of students within their diverse social and cultural settings. The right to education is thus both about universally available open access to education and about what and how education is taught. Violations of human rights to education include, for instance, legislation which discriminate against individuals or groups in the field of education, or the failure to take measures which address de facto educational discrimination. Extreme examples are the exclusion of girls from schools in Afghanistan, or the inferior education for black people under the then apartheid in South Africa. However, educational discrimination also exists here in Europe, for example, against national minorities, such as children from Roma communities. The UN Committee on Economic, Social, Cultural Rights, for example, is concerned about educational segregation from Roma children, including the high number of Roma children in special schools or special classes with inferior educational opportunities and their exclusion in everyday school life. Many reports by the UN Committee of Economic, Social, Cultural Rights and the UN Committee on the Rights of the Child also criticizes that children's educational opportunities differ considerably depending on the social background. Sometimes there's explicit talk of social segregation. This is a severe problem, for example, in Germany. Increased attention is also being paid to sexual harassment and violence against female students and discrimination on the basis of sexual orientation, of gender identity, of LGBTIQ persons in school, for example. Furthermore, the form and content of education can be a violation of human rights too. If schools and teachers preach hate, count tanks instead of apples, or use corporal punishment, this is incompatible with the human right to education. According to the UN Convention on the Rights of Child, education should, among other things, teach children respect for human rights and prepare them for life in a free society in a spirit of understanding, peace, and tolerance. Well, this is not the case everywhere. Let's just look at Kosovo, where segregation of Serbs and Albanians is reinforced by the segregated educational system. Second example, the right to housing. The right to adequate housing requires adequate availability and protection of housing, open, non-discriminatory and affordable access to housing, and decent quality housing. This raises several human rights issues such as homelessness, the lack of affordable housing, discrimination in the housing market, and the fact that many people around the world live in precarious situations. Indeed, the urgency of the human right to housing becomes clear when one considers the housing misery in which millions and millions of people live in the countries of the global south and sometimes also in the countries of the global north. Many people live in informal settlements under miserable, inhuman conditions and always in danger of being evicted. Protection should also be specifically emphasized here. It applies not only to home ownership and rent, but also to emergency and refugee shelters and informal settlements. Notwithstanding the type of tenure, all persons should be protected against forced evictions, house demolitions, harassment, and other threats. Millions of people, however, are displaced not only by wars and conflicts, but also, for example, by urban development programs, land and property speculation, infrastructure measures, or in the run-up of mega political and sporting events. While the right to adequate housing does not per se prohibit ordered evictions and relocations, it does make them subject to strict conditions. These include serious consideration of alternatives to eviction, serious impact assessments, risk and harm minimization, information, consultation and participation of those affected, implementation of the eviction in accordance with the rule of law, with a court order, with the presence of government officials, etc. Special consideration for vulnerable groups, the elderly, the sick, children, etc. The prompt provision of adequate alternative housing, compensation, and access to legal remedies. A blatant violation of the human right to housing is therefore the widespread practice of forced evictions by the state, in which the people affected are evicted against their will, possibly even forcibly, without being adequately consulted, informed, and compensated, and without being provided with alternative accommodation. Of course, evictions should not result in individuals being rendered homeless. Protection is also important to the right to health. My third example. First of all, it is not a legal guarantee to be healthy. No state can give such a guarantee, if only because health depends on many determinants that the state is not able to control, or for good human rights reasons, should not control. However, the human right to health, as enshrined in the International Covenant on Economic, Social, Cultural Rights, confers on every human being the right to attain, I'm citing, the highest attainable standard of physical and mental health. In a nutshell, the right to health means that the state must not interfere with people's health, must protect it from interference, and must take measures to ensure that people have healthy living conditions and above all, that they have access to adequate health care. Here too, the availability of and open access to health facilities play an important role, as does the quality of healthcare, which must meet medical standards. That means with regard to healthcare, the already known criteria can also be applied. In terms of availability, states must ensure that functioning health infrastructures are in place. At the same time, access to medical facilities and treatment should be open to all people in several respects. Non-discriminatory, also and especially in the case of particularly vulnerable and marginalized groups of the population. Physically, that is within safe reach and accessible also to women, children, older people, and people with chronic diseases and disabilities. Economic, in the sense that medical facilities and treatments are affordable and available to all, including poor and socially disadvantaged groups. Informed, in the sense that people have the right to seek, receive, and disclose health-related information, provided that this does not compromise the protection of personal confidence. In the sense of acceptability, medical facilities and medical treatment must be carried out according to the principle of medical ethics and take into account the gender, age, cultural characteristics of individuals or minorities. It is also required that medical facilities and medical treatment are suitable and of adequate quality from a scientific and medical point of view. You can see that the UN Committee on Economic, Social and Cultural Rights interprets the human right to health in a very demanding way. The right to health is obviously violated, for example, when medical experiments are carried out on people without their consent, or when forced sterilizations are carried out. People may also not simply be denied access to vital medical care and must also be treated appropriately. This also applies to mentally ill people. The conditions in some psychiatric hospitals were, and sometimes still are, not compatible with human rights. And with regard to refugees, it should also be emphasized here that every person, regardless of nationality and legal status, has the right to medical care. This even applies to people without papers, that is, who are not legally in their country. However, because they are afraid of deportation, they often do not use public health facilities. Well, the explanations are still quite general, but for the time being, it is only a matter of giving a basic idea of the content of social human rights on the basis of the already mentioned criteria. So, as we have seen, violations of social human rights may occur through acts of commission or acts of omission. This corresponds to three types of state obligations with regard to social human rights. Once a state has ratified a human rights treaty, it has the legal obligation to respect, protect, and fulfill human rights enshrined in the treaty. Obligations to respect form the core of a liberal theory of human rights, which focuses on the protection of the individual sphere of freedom against state interference. They oblige states not to directly or indirectly prevent individuals from exercising their human rights, and where they do, to refrain from the corresponding acts of violation and, if necessary, to remedy their consequences. These are therefore primarily duties to refrain, which any state, however financially weak, can fulfill. Usually, such obligations are formulated primarily in relation to civil and political rights, some of which have freedom already in their very name, such as freedom of assembly, of association, freedom of expression. However, it must be stressed that economic, social, cultural, human rights are also a right of freedom that can be violated by state action, as I've shown or tried to show with regard to forced evictions. Obligations to protect consist of the state's obligation to protect individuals against actual or threatened interference with their legal provisions by non-state actors. Under the obligation to protect, the state has to take steps to prevent others from interfering with the enjoyment of social human rights. The state must therefore intervene if, for example, private companies violate workers' protection rights or cause environmental damage that endangers people's health, to name just two examples. Violations of the duties to protect can thus result from state omission. However, since it is usually a complex question, how a positive duty to protect derived from a human rights is to be realized by legislative and non-legislative measures, there is a wide political margin of appreciation regarding to the question of which countermeasures are to be taken by the state. The choice of means, as long as they are purposeful, and in conformity with human rights, is therefore in principle at the discretion of the respective state and its political decision makers. This applies to an even greater extent to obligations to fulfill. They oblige states to adopt appropriate legislative, administrative, budgetary, judicial, and other measures to ensure that everyone may enjoy their economic, social, cultural rights. The obligation to fulfill requires states inter alia to adopt, for instance, a national housing policy or national health policy with a detailed plan for realizing the right to housing or the right to health. Here, two states have great freedom of action. Thus, social human rights are in no way intended to deprive ideally democratically legitimized political institutions of responsibility for the concrete design of their economic and social systems or their economic and social policies. Furthermore, the International Covenant also explicitly allows the state parties to implement some of their obligations under the Covenant progressively. This is appropriate in many cases. In view of poor resources and the difficulty of overcoming social grievances, many aspects of social human rights cannot be implemented overnight, especially those legal components whose implementation requires extensive state services and long-term action. But at the same time, the UN Committee made clear that states must take immediate action. Lack of resources cannot be used as an excuse to remain inactive. Even the poorest country must progressively implement social human rights as best they can, using available resources and international assistance if necessary, and account for the steps taken. States are therefore obliged to make immediate steps towards the realization of social human rights. Inaction and insufficient action by the state, as well as the discriminatory withholding of benefits, constitute a breach of the obligations to fulfill. So we hold states are obliged not to prevent individuals from exercising their rights, obligations to respect, to protect individuals from interference with their rights by third parties, obligations to protect, and to progressively enable the exercise of human rights through active action, obligations to fulfill. This triad of obligation is widely recognized today, at least under international law. So, what has been said so far shows that social human rights correspond to different types of state obligations, especially within the state's jurisdiction, but possibly also abroad. The traditional idea that social human rights are not rights to freedom but merely demands for social benefits or even luxury rights is thus contrasted here with an understanding according to which social human rights are also oriented towards freedom. In fact, they represent important freedom rights because they aim at a realization of a social order in which individuals can freely develop together with others. On the one hand, social human rights establish a social freedom for people to shape their own lives in an autonomous manner, which neither states or non-state actors may unduly restrict. Social human rights serve, for example, to protect individuals from being exploited economically, from working under inhuman conditions, from damage to their health, or from being prevented from feeding themselves, from maintaining a safe living environment, from being adequately educated, or from participating in cultural life. Incomprehensibly, such defensive and protective functions of social human rights are often ignored by the relevant literature when social human rights are constantly and exclusively presented as demands for social benefits. As social human rights aim to preserve individual and social freedom, they ultimately represent freedom rights in the best sense of the word. Furthermore, the real conditions must exist or be created so that people can actually act autonomously and lead to a self-determined life in community with others. This is where the obligations to fulfill come in. They oblige the state to create the real conditions that make freedom possible in the first place, as far as possible at least. This also includes active measures against extreme poverty, unemployment, hunger, illness, homelessness, and social exclusion. Ultimately, hardship is simply lack of freedom for the people who suffer it. It is not by chance that freedom of want is found in the preamble of the Universal Declaration of Human Rights. However, the removal of de facto obstacles of freedom does not come about by itself as it were via the market, but must always be achieved legally and politically. At the same time, these rights of freedom are linked with the claim that they apply equally to all people, and as such also represents rights of equality. Equality, as conceived in human rights context, does not, as is often assumed, aim at social leveling and uniformity, but on the contrary, that all people are equally given the opportunity to find and realize their own special life plans for themselves and in community with others in freedom. Human rights empower people to pursue their diverse life plans, to express different opinions, to manifest their own convictions, to maintain their particular cultural tradition. As my famous colleague Heiner Bielefeld says, human rights are diversity friendly. At the same time, all human rights also represent solidarity rights. Of course, human rights are rights to which every individual is entitled. In this respect, they are individual rights. But they are not purely individualistic rights. Human rights are oriented towards living together. Without social togetherness and social support, the implementation of individual human rights is hardly possible. Individual autonomy always requires social participation, solidarity, and protection against social exclusion. And at the same time, the demand for and implementation of social human rights also leaves its mark on the community. They are geared towards a political order in which all people are not or no longer excluded, but can develop together with others. So let us note at this point, in the national human rights discourse, social human rights have gained considerable importance over the past 30 years. The understanding of social human rights and the obligations arising from them has also changed considerably. However, there are still major understandings, reservations, and also political resistance to social human rights that need to be overcome. This is especially true when it comes to implementing social human rights. I'm not sure if you have enough time. I can tell a little bit about what happens if social human rights are violated and not adequately implemented. Martin, still I have? Okay. I don't dare to do so. It's not up to me. Unfortunately, what happens if social human rights are violated and not adequately implemented? Unfortunately, the international community has provided UN human rights protection with only weak monitoring procedures. At a United Nations level, mainly reporting and complaints procedures are available to monitor the implementation of human rights. Under reporting procedures, states must submit reports on how they're implementing human rights treaties. The respective United Nations Committee reviews these reports, also taking note of additional information from national human rights institutions and non-governmental human rights organizations, and then makes recommendations to states on how they can better implement the respective human rights treaty. The UN Committee on Economic, Social, Cultural Rights, for example, made the corresponding recommendations to Slovakia in 2019. With the entry into force of the optional protocol adopted in 2008, there is also a complaints procedure for the International Covenant on Economic, Social, Cultural Rights. Provided that the respective state has ratified the optional protocol, people who feel that their rights under the covenant have been violated can file a complaint with the committee. However, the national legal process must have been exhausted or be unavailable. Slovakia ratified the optional protocol as early as 2012, Germany only 10 years later. It was really a struggle for us to lobby the ratification of the optional protocol there. The reporting and complaint procedures enable the committee to show to what extent social human rights are not being implemented or are being violated. Although the committee's final recommendations are not binding, they have an important orientation and corrective function. They point out the challenges that policymakers must address in order to better protect and implement economic, social, cultural human rights. Now, at the level of the Council of Europe, the European Court of Human Rights can pronounce binding judgments that must be implemented. However, with the exception of the rights to property and education, the European Convention on Human Rights does not contain any economic and social human rights. Therefore, violations of such rights cannot usually be brought directly before the European Court of Human Rights, but at best indirectly through some other rights enshrined there, such as the rights to life, the protection of private and family life, or the prohibition of discrimination. Direct, explicit protection of social human rights within the Council of Europe is provided by the European Social Charter, which, however, is rather a weak instrument and, moreover, is not given sufficient value. By the way, the revised European Social Charter was ratified by Slovakia in 2009 and by Germany in 2021. But what about going to national courts? Can I, for example, go to a German court and claim that one of my rights guaranteed in a human rights treaty has been violated? While in the case of civil and political human rights, such as freedom of assembly or expression, this is widely considered possible. German courts are far more reluctant to do so in the case of social human rights. In most cases, the courts assume that the rights enshrined in the International Covenant on Economic, Social, Cultural Rights are not sufficiently clear and specific, or at least require further acts of implementation, that is laws, in order to be enforceable. This also seems to be the case in Slovakia. At least the United Nations Committee also recommended to Slovakia that the state party take the appropriate steps to increase judges, lawyers, and prosecutors' knowledge of the covenant in order to ensure that its provisions are taken into account in domestic court decisions. Well, the same can be said to Germany, by the way. It should be noted, however, that social human rights have already been concretized to a high degree, and that certain aspects of social human rights have quite suitable to be asserted directly before the courts. But if social human rights and international treaties do not automatically give individuals an enforceable legal claim in domestic courts, what can be done? In this respect, it is important that national law adequately covers the scope of protection of social human rights. It is particularly helpful if social human rights are enshrined as fundamental rights in the national constitution. However, many national constitutions, including Germany's, have no or hardly any basic social rights. By the way, this does not mean that social human rights in Germany are completely without constitutional protection, but this is another point. This is about usually where labor and social law come into play, from which, if necessary, declarable legal claims can raise before national courts. Other national constitutions contain basic social rights, such as the constitution in Slovakia, although I do not know what constitutional significance is attached to social rights in constitutional practice here. But I was surprised when I read the constitution in Slovakia that it contains a number of fundamental social rights. However, demanding better implementation of social human rights does not necessarily require legal action. As important as court rulings are, better implementation of social human rights can also be achieved politically. And this is where I, as a political scientist, come in. For this, it is important that people organize themselves and get involved together. Ultimately, the comprehensive granting of social human rights must also be fought for politically, for example, by working to ensure that national or European law is developed in such a way that social human rights are better implemented. Non-governmental organizations are an important driver of human rights policy. They document human rights violations, support those affected, engage in human rights education, form powerful networks, conduct protests and campaigns, or try to move the big wheels of politics by actively lobbying parliament and government. United Nations monitoring of social human rights can be used to increase public and political pressure to better implement social human rights at a domestic level. Unfortunately, in many countries, it is precisely those people who stand up for social human rights who come under pressure. For example, when they defend themselves legally and politically against exploitive working conditions, against health-damaging environmental pollution, against arbitrary land seizures or forced evictions. All this could be cause for despondency. But it is precisely when human rights and human rights defenders are threatened that action in solidarity is needed. Everywhere, there are committed people who stand up for their rights and for the rights of others. And in many places, there are people and organizations who support them, of course, hopefully without patronizing them. It is precisely the support in solidarity across all national borders that has proven to be important in order to protect and implement social human rights and those who stand up for them. So, thank you for your attention.
discussion is open. Please raise your hands and formulate your questions. First one. And please introduce yourself.
Sure. I'm Josef Majerník. I work here at the Institute of Philosophy. And at the beginning of your talk, you mentioned epistemic communities as one of the key actors in the process of safeguarding and realizing social human rights. And so I would like to ask you to expand on that a little bit. So on one hand, what specific epistemic communities do you have in mind? And on the other hand, how do you understand their role or their function in this process? Thank you.
Should we collect or?
Yeah, it's up to you. Second question, please.
Thank you very much for your lecture. It was also encouraging. I would like to touch this previous question by comment and pointing at the problem in Slovakia with the so-called epistemic community. Because as I observe the role of NGO in protecting social human rights, so I think that NGOs in Slovakia from the 90s neglected the social dimension of human rights, and the situation was at the time as our joining the European Union, that social rights were understood by public or by politicians and mass media as a relic of communist ideology, not as a part of a very dignified cultural tradition. And human NGOs which so-called defend the human rights often concentrate on cultural rights and not on social rights. For instance, the right to housing. No NGOs focus at the right to housing was active in Slovakia. Many topics of social rights were imported from international NGOs, for instance, segregation of Roma children in education and the special school problem, but absolute neglect was to desperate housing condition of Roma children, to the neglect of different mother tongue of Roma children, which desegregation will not solve, and also the problem of inclusive programs and assistance in school. So I doubt the role of NGOs in Slovakia as helping for social human rights sensitivity in our country. So, and also the tradition in academia and university of social human rights has been very poor because of this fear of being labeled as some who support this communist ideology. Really, from political science department, the topic of social human rights disappeared, and I think that there was no part of educational curriculum in Slovakia.
Thank you very much. Third question. It was sociology, Zuzana Kusa
sorry,
from the Sociological Institute of Academia.
Myself, I am sociologist, and I observe the situation of social human rights in Slovakia.
Okay, Professor Sedová, Tania Sedová, please raise you.
First of all, I would like to express my thanks for your excellent lecture, and I like to raise a question which is relating to my ethnic question as well. Also back to this concept of epistemic community. this difference access to human rights, including social human rights, from political scientists and from historian. I have in mind this thesis by Moyen that human rights, including social rights, are last political utopia. Thanks.
Okay, we completed 3 questions, please.
But can I have also the question? One question, and this at the beginning of your lecture, you have told that perhaps practical examples count much than the philosophical arguments. And as I have read many times, International Declaration of Human Rights, there are exact reference to tragical historical examples that show why respect to human rights and people's dignity is so important, because there is a clear causal link between humiliation of people and nations and the hate, hatred, and broken of peace. That there is this argumentation that why human rights are so important for peaceful living together is very clear in the very Declaration on Human Rights. And I think that it's much more important, this practical, tragic experience of humankind than a very sophisticated philosophical argumentation. Sorry, I apologize to my colleague from Philosophical Institute.
Okay, should we collect another question, or would you like to start these answers?
I try to start here, because if not, I'm losing. Yeah, so where to start? Perhaps as a political scientist, it's always difficult to, as a political scientist to talk about law. So my first conflict is sometimes with those who are teaching public law, especially in Germany. Those who are teaching international law regarding all these United Nations documents and so on, I guess I'm in line with them. But in public law, you're usually talking about obligation to respect, yeah, to protect, yeah, but to fulfill, it's difficult. And even there's in public law much misunderstanding that economic, social, cultural rights only refer to the obligation to fulfill. And this was part of the point that I tried to make, that we also have to defend social human rights against infringement. With regard to historians, yeah, there's, of course, they are very dedicated to the development of historical documents to human rights, and so they come to the point that this is rather a Western, let's say, a Western intervention, a Western thing. I'm not sure about that from a historical point of view. If I read the elaboration, or if I analyze the elaboration of the Universal Declaration of Human Rights, there were so many influences from different parts of the world. And furthermore, well, I was in many parts of the world, Latin America and Africa and some Asian countries. I've read many reports from these countries. I listened to many persons from there. And I always have the impression that everywhere there are people who are fighting explicitly, or at least implicitly, for human rights. Nobody wanted to be arrested arbitrarily. No one wanted to be tortured. Everyone wanted to have the freedom to criticize the government, and so on and so on. And this also is true for social human rights. Nobody wanted to be evicted forcibly, and nobody would be have restricted access to medical care and so on. So this is a very practical, I would say from a philosophical foundation, it is not enough, of course. But as a political scientist, I would say this is enough for me in practice to defend human rights and see them globally and universally. And Moyne, well, I read even a paper, wrote a paper with regard to Moyne. I think he has a very reduced understanding of social human rights. I'm not sure whether he really was concerned with social human rights, but criticizing them and all human rights as companion to neoliberalism. If you take social human rights seriously, and I do that, many others do not, then this is also something against neoliberalism, a protection against the negative consequences of liberalism. Of course, social human rights do not forbid privatization, but if privatization is carried out, for example, of the health service or the water service, there are kind of human rights obligations to respect. And this is that the availability for all, the accessibility for all, the affordability for all, and also the quality of the water, for example, must be assured. So I think we can, if we take social human rights seriously, they are really something to also to fight off the negative consequences of neoliberalism. But of course, it doesn't change neoliberalism. These are structural questions, and so there would be, we would overdo it with the social human rights if we think they are able to change the capitalist system. Yeah, with regard to the relict of communist states, I understand this, but my feeling is that, well, in fact, socialist states were involved also in the inclusion of these rights in the Universal Declaration. But they were not the main driver, by the way. I just come back to it again. However, I have the impression, well, I understand social human rights as individual rights. You can claim if they are violated. For example, the right to health or the right to something. I have the impression that this was not given in the communist states. They had the impression that the state has to provide benefits to people, but the possibilities to defend themselves when these benefits were not given were quite restricted. So it was rather benefits by the state, given by the state, than rights which can be directed against the state. So I think we must change a little bit our understanding of social human rights, and I think the communist or the socialist version of the social human rights interpretation was, is not adequate anymore. So perhaps we have to do this. By the way, the Universal Declaration of Human Rights, there were different, this might be interesting, there are different resources why social human rights came in. First of all, throughout the work of the text, the Universal Declaration of Human Rights was a response to Nazi terror and the Second World War. I'm citing the barbarous acts which have outraged the conscience of mankind, as the preamble of the Declaration states. Not only the inclusion of civil and political rights, but also economic, social, cultural rights was tied back to the terrible experiences of the Third Reich and the war years. At the same time, the fathers and mothers of the Declaration were under the impression of economic hardship in the post-war years. And furthermore, that's interesting from now, because I would say the human rights treaty that would least be ratified by the United States of America is the International Covenant on Economic, Social, and Cultural Rights. But surprisingly, an important impulse also comes from the United States. Freedom of want was one of the 4 famous freedoms formulated by the then US President Roosevelt in 1941 as the basis for the New World Order of the Second World War. And the demand found its way into the Universal Declaration of Social Human Rights. However, during the drafting of the Declaration, the Truman administration increasingly distanced itself from the corresponding demands. And during the final debate in the UN General Assembly, Eleanor Roosevelt, also the widow of the president who died in 1945, and chair of the UN Commission of Human Rights Committee, even declared, I'm citing, "My government has made it clear in the course of the development of the declaration that it does not consider that the economic, social, cultural rights stated in the declaration imply an obligation on governments to ensure the enjoyment of these rights by direct governmental action." But there was an impulse from the United States. And finally, and this is perhaps the most important point, it is little known that delegates from Latin America had a decisive influence on the Universal Declaration of Human Rights, partly because they have already enshrined these rights in their constitution. And in doing so, they draw on their own constitutional tradition, which knew precisely such rights. That's just to relate, is this only relate to communist states and so on. Role of NGOs protecting human rights. I'm not sure, I looked at the report I told you that there was a kind of report of the Slovakian state to the International Covenant on the International Committee, the Committee on Economic, Social, Cultural Rights from the United Nations, and there were recommendations by this. And the state took into consideration also information by NGOs from Slovakia. So there are a number of NGOs here in Slovakia. I cannot assess how good they are or what they do, but I have a lot of parallel reports from NGOs from Slovakia about social human rights here. So obviously there are a number of non-governmental organizations who work on that topic.
Sorry, I have spoken about the 90s and the first decade of before our entrance to European Union. Now the situation is different.
Okay, yeah. Thank you very much for clarifying this. Yeah, I guess so. Even in Germany, NGOs working on social human rights mostly were established in the 2000s, not in the 90s. With regard to mother tongue, it's a very difficult question. The right to education does not oblige states to accept other languages in school, for example, than the official languages. There's no obligation to do so. But it might be sensible to do so from a human rights perspective if you have a multilingual society and national minorities. And what is not, what would be a blatant violation of human rights would be to prohibit national minority languages, even outside of the school. So we have a night of number. Look at Turkey. There was a prohibition of Kurd language. And even in the Balkan states, of course, we have a Russian minority there, and they, from a human rights perspective, should be able to maintain their language there also. In Germany, we also have some national minorities who, yeah, okay. So, but it's a difficult question for multilingual societies. I think the most progressive constitution is there perhaps, or regulations there perhaps in South Africa. And in New Zealand, they introduced recently also, interestingly, now my English, the language of those who are not, I would say, taubstumm. Yeah, as an official language in there, because it's also language. So. And rights is a last political topic. Yeah, it was about Moin. Yeah. I'm I'm not very impressed of that book. And with regard to the epistemic role, sorry? With regard to epistemic role, yeah, there are quite a number of documents which were elaborated by academics, and let's see if I find some. Yeah, anyway, there were academics and human rights organizations develop a kind of guiding um, guidelines, for example, with regard to the obligations of the economic, social, cultural rights, with regard to the extraterritorial obligations of economic, social, cultural rights, and so on. There are the Limburg principles, the Maastricht principles, and so on. There are quite a number of interesting work together from, let's say, progressive academic side. But now I have forgotten your concrete question. Sorry for that.
Yeah, the question was which epistemic communities do you have in mind within academia, and what's their role in this process of safeguarding and realizing the human rights?
I consider the rolling in, as I said, human rights are living instruments. And so it is very important to adapt them to new challenges. And I think this is where academics may come in order to show how, for example, human rights respond to new transformation, climate crisis, for example, or artificial intelligence. This is a challenge for human rights because sometimes we have blind spots in the human rights discourse and bias in the human rights discourse. This is a challenge for academia, but also a challenge for human rights organizations, non-governmental organizations. Look, for example, violence against women in privacy was not considered as a human right violation for a long time until feminist movements make this point. And look at the discrimination aspect. So today, of course, our understanding of discrimination is completely different to the understanding of discrimination when the Universal Declaration was elaborated. In Germany, homosexuality was prohibited for a long time, even in the second part of until the 1960s, I guess. So there's much what academia can do in order to interpret human rights in order to adapt new transformations and adapt new challenges for the human rights discourse. This is so, yeah. And also to defend it, because human rights can be overloaded too. Of course, not everything which is with regard to social human rights, which we want to implement with regard to social policies, is really a human right obligation. We should be aware of that too. So we have. Yeah.
Okay, I see another question. Dr. Kuchtova, please.
Hello, I'm from the same department as Josef was speaking from Institute of Philosophy, and I have one question regarding post-colonialism. Like, what do you think the discussion could be with post-colonialism? Because you present the idea of universal human rights, which is very important, I understand, in nowadays world, but also these universal rights are applied to specific contexts, as for example, a context of Roma community in Slovakia. And this is interesting to relate it to this concept of housing. What does it mean to provide housing for everyone? And for example, in Roma communities, they were originally nomad nations, as we know, right? So for them, the concept of housing would probably not be defined in the same way as European concept of housing. So and we know from history that they were forced to settle in Europe, and so when Marie Thérèse, this political scientists when they define these universal human rights today?
Mm-hmm. Should I react directly?
Maybe.
Okay.
If not, if we do not have any further question, then start please. Okay, please.
It will be better to give them response to what comment.
Moment. So we started to collect the question. Please raise.
Okay, I take the liberty to raise a question because from your point of view, what do you say about who today is competent to invent or to write or to conceptualize social human rights? Because it seems to me that we are witness now this shift from equality to non-discrimination. And from my point of view, this creates problems for social human rights, how we can implement it then.
So you asked who is the author of the interpretation, or
by whom is rights are invented, by whom social rights now? Because after the Second World, it was clear, it was liberal, it was social democratic party. But now,
Please advocate.
yeah.
Good. Third, maybe question in this round. Okay.
so I hope my English capacity is now reducing because I have to concentrate very much to speak English. No. So I hope I explain myself, please, if I do not. With regard to postcolonialism, I think it's a very important impulse from the postcolonialism to human rights discourse. Exactly what you're saying. I don't have to repeat it. But I think if we have a progressive understanding of human rights, this can be very well included. For example, I told you with regard to these criteria, acceptability means, of course, cultural acceptability. This means, of course, acceptability of other forms to produce, other forms to live, other forms to housing, and so on. And human rights are able, I said they are diversity friendly, are able to empower those who are fighting just for that in order to maintain their culture and traditional culture, as long as they are not harmful. Of course, social human rights are also, or human rights in general, may change societies. But the important point is that must be changed from inside and not from the outside. The outside can assist perhaps this process, but these are processes within the society. And in order to prevent the old problem of imperialism, also with human rights, is the art of listening. Listen carefully what people are saying and demanding in those countries about who we are talking about, in the global south, in South Africa, in Zambia, Namibia, in Costa Rica and Mexico, what they are saying, what they are demanding. And if we do that, then I hope that we do not fall into the same trap that we have done before historically. Because you are right, we had a kind of Western understanding of human rights, which was sometimes not very context sensible. And this, in my view, in my perspective, concept of human rights, this is being included. But of course, we have to fight for that too, because we always have these very reduced interpretation of human rights, just as Moyne, for example, does. So, yeah, it's interesting, the differentiation between equality and non-discrimination. You are completely right. This is a difference. I must think it a little bit over. Sorry to not give you an answer. With regard to who is intervening, well, I try to say that there's no intervening of social human rights. They were always there. It's just the kind of intervening, a new interpretation, a progressively interpretation of human rights. And these were the drivers of change. And I'm not sure if I answer your question now, but these, of course, can they claim authority? United Nations Committee, human rights organizations, academia who are promoting. It depends if their concept of human rights is accepted or not. The authority is not given. They must convince those who have a different concept. I'm not sure if I really get the point, but
social policy at the level of European Union and Slovak. It was related with this right for disabled people with this article which has been adopted by Slovak Parliament, and which as a colleague we write a letter to European Parliament, and we received answer that it is a matter of national state, the social policy. Not, but with respect to Roma discrimination in education Slovak system, it is matter of European Parliament, European Commission. But social policy, no. So this hypocrisy, it strikes me very well.
oh, yeah, I fully agree with you. Looking at the European Union, there's many things to criticize, but anyway, social policy is not part of the European policy. Unfortunately not, or in some cases, yeah, well,
in some cases, yes. In different
but this is a political negotiation between the national states. What they try to make a European policy and not a national policy. And if we look at the refugee policy, which is European policy, wow, it's violating blatantly human rights from a human rights perspective. And the interesting point is the impulse, one of the impulses or one of the economic, social, and cultural rights was also to ask which are the human rights obligations of international institutions and international corporations. That means we can assess also from a human rights perspective what the European Union is doing, what other institutions are doing, for example, the World Health Organizations, the Food and Agriculture Organizations, and so on. So is there an obligation for international institutions, which are not part of UN of human rights treaties, for respecting human rights? And if not, what would be necessary to enable us? Yeah.
Thank you very much. It was very interesting lecture because the problem of the human rights is almost interpreting the ideological attitudes and ideological conflict-driven understandings of human rights. We spoke about the tradition which has social, economic, and cultural rights in the terms of the communist past in our region and how difficult it is to promote such rights as a human rights in our region. Yeah. On the other side, what struck me was that in your lecture was mentioned right to education, right to health, right to decent housing, and in the terms of equality, this is kind of social justice. Yeah. But we didn't spoke about the obligation for corporations to respect, protect, and fulfill social human rights. And that's my question. What is the relationship between social human rights agenda and obligation of corporation, international corporation, to follow, protect, and respect them?
I have left it out in order not to make things too complicated. But it's a big issue. It's a very big issue. Above all, the discussion on social human rights has considerably revived the debate of the human rights responsibility of particularly transnational companies. Of course, they have strong influence on human rights, negatively and positively. And so what shall we do with them? Do they have human rights obligations? Well, at least it has given impetus to demands that transnational active companies be held more accountable in terms of human rights. And this was a starting point of the UN guiding principles of human rights in business. There's a guiding principles and several national action plans on business and human rights in many countries. Quite a number of countries have an action plan how to regulate that. And in June 2014, the UN Human Rights Council even took steps to elaborate an international legally binding instrument to regulate the activities of transnational corporations and other business enterprises. So there's much discussion on the level of the United Nations. There's also much discussion at the moment in Germany. We have a new law which obliges private companies to respect human rights when they act transnationally. Or the same is true with France. Well, that's different. Our law is not the very best, so there's much criticism from non-governmental organizations, but at least there is a law now. And furthermore, there's a big discussion now if should be a European law. There's exactly about this topic. There's a discussion if there should be a European law to ensure that European companies do not to respect human rights in their transnational activities. So there's a fight what are the terms of this law? This is very politically controversial. But there's really a very lively discussion about that point. And thank you to add this in order not to be, in order to have the possibility to mention that.
Is there any most important question which has to be raised now and without which we could not fulfill the program of this meeting? If not, I would like to say, Professor Michael Krennerich, big thank you for this comprehensive, details-driven and very competent introduction of social human rights agenda in a very complex world now. I would say we would like to continue in this kind of discussions, and what is for me the main gain from this time is that your introduction sentences about the human rights agenda is not so much philosophical agenda, but driven with the experiences of tragical injustice, and this is the question how we survive such injustice in our lives. I'd say that the role of epistemic community is very productive in that agenda, and I'm very happy that we provide the evidence for this approach in Bratislava and that space, and in Philosophical Institute with our guests from other academical institutes, Slovak Academy of Sciences. So thank you very much for being here. Informal part of our meetings is open now, and if you have another question, maybe how to public your very interesting remarks and how to make possible further cooperation for Journal for Human Rights, Zeitschrift für Menschenrechte, I would say that's the right moment for making it. Thank you very much, and see you next time.